Welcome to Davis Malm. We're going to be covering a range of interesting topics that I hope will be informative and interesting to you.
So I am here to talk about politics in the workplace, and basically what I'm going to be telling you is that probably the best place to be to get away from the politics and get a break would be the workplace. The survey data that people have spit out there, or some of it anyway, is that there's a lot of people that talk about and engage in political discussions at the workplace, but apparently there are a number of people that aren't comfortable with it and don't like it. You've got many people regretting having political discussions. Some feel it hurts the work environment having political discussions, and some people think that the more it happens and occurs, it's going to make it very uncomfortable. So there's a good reason for employers to eliminate political discussions in the workplace, which can be done. And some of the issues that arise from it is a lack of productivity, a loss of attention and focus of the employees. It can harm morale and relationships, particularly given the way it seems to be today. It can also harm customer relations to the extent there's discussions that customers overhear or get involved in. And it can implicate numerous labor and employment laws, which could create some difficulties in the workplace or potentially create claims arising from those discussions. There is no First Amendment right to engage in political discussions in the workplace. So free speech applies only really to government action. If you're obviously working for a public employer, you've got different issues. But for a private workplace, you can eliminate and prohibit political discussions. They have no constitutional right to that type of expression. However, you also don't have any right to displaying the campaign paraphernalia. So Trump signs, Biden signs, Harris signs, you can't be putting that stuff up. And you can prohibit all of that. You can't solicit campaign contributions. If you want to prohibit that, you can. And wearing even campaign buttons, you can prohibit that. And that will all work and help try to keep more productivity and calm in the workplace. What's the risk to doing all that? The risk to doing all that is, one, you don't equally enforce the restrictions if you have those restrictions. If you don't, then that could lead to claims of discrimination, harassment, or retaliation. In addition, that political discussions can implicate certain issues of race, gender, and religious beliefs. So if a supervisor expresses support for a candidate, position on those types of areas of discussion, abortion, immigration, gender pay, equality, it could also lead to claims of discrimination. So those are all reasons that you may want to seriously consider limiting it because it can prevent further claims from arising, which otherwise wouldn't be there if you're not having these types of discussions. The one thing you've got to be careful about is the National Labor Relations Act type activities. Those are still protected, so you cannot prohibit those. And what those generally entail is employees have rights to communicate about issues in the workplace, wages, hours, terms and conditions of employment, benefits, that type of thing. So you got to be careful not to do that. And that's where you may have some decisions to make when there are some prohibitions that you put in place on discussing political speech. For instance, there could be discussion about discrimination in the workplace or wage increases. If it's tied to the political campaigns of an individual, that could be restricted. You can't restrict them from discussing, we need policies, or there's too much discrimination going on in this area, or we should have our wages increased. If an employee wrote up a sign that said, "Vote for Smith, protect our wages," that might be able to stay up and put that on his cubicle. That's going to be a closer call. Whereas if he put a Trump sign or a Harris sign and made some statement, it's a campaign type paraphernalia, that could probably be more required to be removed. The other thing you got to watch is trying to limit discussions during non-work time or in non-work areas. Those also you would have to be careful not to make your policies that broad that they would cover those. There are also some limited state law exceptions. In Massachusetts, an employer is prohibited from taking adverse actions against employees or promising more favorable terms to influence employees' votes or political contributions. Other states' laws, which I'm not going to cover, they're too numerous, and I think most of us are operating in Massachusetts, also have certain rights related to political discourse. So if you do have offices in other locations, we'd have to key on those states and see what, if anything, exists. So what are some actions that we would recommend you take as an employer? One would be implement a written policy. Prohibit and restrict political discussion and expression. Tie the restriction to conduct that harms productivity or impacts customer relations, things that relate to the legitimate employer interests. Include a carve-out in the policy for those NLRA rights that I mentioned that allow for discussion of wages and anti-discrimination, that type of thing. And then train your managers on what's acceptable and what's not. Yes?
Do you specifically have to call out political discussion, or can you just put it into general, like derogatory?
I think you'd put it in general terms about political discussions, political candidates, who to vote for and why, and then have your caveat, you know, this does not impact your rights under Section 7 NLRA to discuss, and then give those, you could give some examples of what the things are can be discussed. So that way it's protected. And you can point to that to say this is not intended to limit those. You also want to make sure that if you do implement these policies that you consistently enforce them in all circumstances so that everybody's treated equally. You want to remind your employees about your other policies that cover anti-discrimination, harassment, retaliation, social media, because sometimes those get tied in with this political discussion and people going overboard. So you've got that caution also to keep people in check and try to limit the types of activities. Massachusetts provides to, employers should provide employees 2 hours after the polls open to go and vote. Does not have to be paid leave to do that. And you want them to ask for it in advance. They're supposed to ask for it in advance. Not everybody does it that strictly, but just so you know, they are entitled to go and vote for 2 hours right after the polls open.
So you mentioned social media policies there. So how can that tie in if someone's out in their social media and they're touting, political things that might?
Yeah, so the social media policy would be the use of firm facilities, computers, website, any of that for social media. If somebody's at home and they have their own Facebook page, you can't do anything like that. What we have advised, depending on the level of the employee, some companies might suggest or encourage a high-level executive employee to state on their Facebook page that this is my own personal view and it's not the view of company X or company Y. But other than that, if somebody's doing their own thing at home, no. It's really your limit. Social media policy is to limit the use of the equipment and facilities of the workplace.
All right, good morning, everyone. I'm going to be talking about AI in the workplace. This is sort of a topic that we're hearing more and more about in the news, and it does have some implications for employers that we wanted you to be aware of. So, what is AI? Broadly speaking, it is technology that enables machines to understand and analyze information in a way similar to how we as humans do so. It has a number of applications in the workplace. Some of you may have been using some of these tools already. Job applicant screening tools, so resume scanners. If you're hiring and you're getting a lot of resumes, this can be a way to cull through the volume. Some employers are using video interviewing and evaluation of candidates based on their facial expressions and their manners of speech, testing that assesses an applicant's fit, monitoring current employees using technology if they're working remotely. These are all some ways that employers are using AI. So a few things for employers to be particularly mindful of when using this technology. First are potential discriminatory uses of AI. First is disparate treatment. That's when an employer is intentionally discriminating against members of a protected category. So an example here would be an employer says, I'm not hiring any women for my accounting department. I only want to hire men. That's disparate treatment, intentional discrimination against a protected group. Disparate impact is when you have a facially neutral policy that ends up having a impact on a protected group, even if that isn't necessarily the intent. So an employer says, I only want to hire people who are over 6 feet tall for my accounting department. So women tend to be shorter than men. That policy, although it's not expressly saying no women need apply, it is going to have an impact disproportionately on female applicants. So how does this dovetail with AI? The same prohibitions that against discrimination in the sort of normal context also apply to employers' use of AI. The EEOC has issued guidance that says that AI can violate prohibitions against disparate impact discrimination if the tool has an adverse impact on individuals of a particular protected category. The employer can't show that the use of the tool is related to the job and consistent with business necessity, and a less discriminatory tool was available but not used. So essentially, you can be liable for discrimination based on your use of an AI tool, even if no humans are making any decisions or policies. And employers can also be liable for disparate impact that results from their use of AI tools from a third-party vendor. So it's not sufficient to say, oh, I subscribe to this platform or this software that's available from another company. If you as an employer are using it and it has a disparate impact on people in a particular group, you could be potentially liable. So how does this happen? Because AI sort of learns based on the information that it's provided with. And so if you have potentially some bias that's going in, then that's what the AI tool is going to learn, and it may result in bias in the output of the program. So just to give a couple of examples, these are real world examples. There was a big technology company used an AI resume scanning tool for applicants for software engineers. So the tool was trained using resumes from current software engineers. The company liked their current employees. They wanted people who had similar experience and backgrounds. And the tool, based on the largely white male current group of employees, the tool learned to downgrade applicants who had went to women's colleges, resumes that included the word women. The most favorable applicants, according to the tool, were people whose name was Jared and people who had played high school lacrosse. So another example is an HR company who developed facial recognition tools to use in pre-employment assessments of candidates. An FTC complaint was actually filed alleging that the tool was racially biased because it read black faces as more angry than white faces. People with certain disabilities who don't tend to make eye contact or from cultures where eye contact is not favored, those people were also disproportionately disfavored by the tool. And so the company ended up agreeing to pull it from the market. So those are just some examples of how you need to be aware of discrimination claims if you're using some of these tools. Really want to make sure that they've been tested and proven not to have potentially disparate impact results. Another area where AI comes into play is wage and hour issues. So just a reminder, the Fair Labor Standards Act, federal law that governs wages, requires payment for all time that the employer knows or has reason to know that work is being performed. And the burden is on the employer to be aware of when the employees are working, to have records, and to pay them for their work time. So especially with remote workers, a lot of employers are using these tools to measure keystrokes, eye movements, internet browsing. That's how they're checking that people are working. The problem with these tools is they don't necessarily account for all of people's actual work time. If they're on the phone, they step away from their computer, they're looking at paper documents, they're out at a meeting with clients or colleagues, that may not be captured by the remote monitoring tools. So if the tool is deducting work time based on its misperception that people are not working just because they're not at their computer, that can result in FLSA violations according to the Federal Department of Labor if the company ends up not paying people for all of the time that they're actually working. So if you're using tools like this, it can be a good starting point, but you want to make sure you're doing more to understand when are people actually working, and so you can pay them for that. A few other ways that AI can impact employers: risks of disclosures of intellectual property and confidential information. So if you have employees who are using ChatGPT or other chat-based AI platforms to do their jobs, if they are disclosing confidential company information and asking their question or saying, please write me a memo about XYZ, and in the process of doing that, they're giving away company information, the AI tool is going to learn that information that the employee has provided, and there's a potential that the AI program will provide that information to the next person who comes with a ChatGPT question. So you need to make sure that employees are not improperly disclosing material that they should not be to these tools. There's also a risk of inaccurate information that employees may obtain from AI tools. So I think, a lot of these platforms are pretty good, but they're not 100% accurate all the time. And if employees ask a question, they get an answer, it's not actually the right answer, and they improperly rely on that, that can lead to problems as well. This is a new technology. The law is pretty slow generally in sort of catching up to the modern world, but the same rules still apply. Discrimination, protections, wage and hour, confidentiality, these are familiar concepts to you as an employer, and you need to be mindful of how the new technology may impact your compliance with these issues. So AI is helpful, can't replace human beings quite yet. We still need to have oversight and understanding of what these tools are doing. And we do recommend that you implement policies around how these tools should be used.
All right, I'm going to talk to you about the NLRB, the National Labor Relations Board, and its enforcement of the National Labor Relations Act, the NLRA. There was a case last year called Stericycle, and in this case, there was a new rule that really shook folks up, and it made us have to be very, very cautious about handbook provisions and rules and policies that we put in place for our employees. So as background, you've heard a little bit from Larry and from Michelle about the NLRA. The NLRA under Section 7 protects non-supervisory employees' rights to engage in what's called concerted activity. And concerted activity consists of, I'm going to the second bullet now, the right to engage in activities for the purpose of collective bargaining or other, and this is the important part, mutual aid and protection. So as Larry mentioned, this is sharing of information about terms of employment, about wages, about treatment at work, harassment, discrimination, treatment by bosses, etc. The NLRA also protects in Section 7 the employee's right to join or assist in a union, collective bargaining, and working with one another to address work-related issues and speak about those issues. And then it's followed by Section 8, which makes unlawful an employer interfering with the employee's exercise of those rights through any interference or restraint or coercion of employees with respect to their rights to share in communication and concerted activity that could be ultimately related to union organizing or not. So this decision that came down last year, it establishes new limits that are very, very strict on any policies or provisions that might chill employees' rights to concerted activity under Section 7. And the new standard is that it is unlawful if the if the policy that you have in place or the handbook provision or the rule that you have in place for employees could be interpreted by an employee as limiting their rights under Section 7 by dissuading the employee who is economically dependent on the employer and what employee is not from engaging in that activity. So we now are looking at all of our policies and practices to determine whether they could be interpreted by an employee as preventing them or coercing them or restraining them from sharing information with coworkers, participating in any kind of concerted activity related to terms and conditions of employment.
Is the could be part of it a reasonable person standard, or is it an interpretation by the court into could?
Good question, and that's the key to why this is so difficult and dangerous, is that it is not a reasonable person standard. The NLRB, who issued this decision, specifically addressed that there could be alternative readings or alternative understandings of a given policy, but if an employee could interpret it as precluding them from participating in any kind of concerted activity, then it would be then there'd be a presumption that it's unlawful. Then the burden shifts to the employer to have to prove that in fact it is a legitimate lawful policy. When a challenge rule is determined to have a reasonable tendency to chill employees from exercising their rights, meaning an employee could interpret the rule or policy as precluding them from participating in concerted activity. Again, as I just said, the rule is presumed to be unlawful. And then the burden shifts to the employer to show that this is a legal policy. And the way they can overcome this presumption that it's unlawful is by showing, number one, and they have to show both, that the rule advances a legitimate and substantial business interest, and number two, that the employer is unable to advance that interest with a more narrowly tailored rule. Basically, there's no possible alternative to this rule. So let me ask you this question. Who thinks that a rule that prohibits employees from sharing information about their compensation would be lawful? Okay, no. I mean, obviously a rule under this standard that explicitly prohibits employees from sharing information about their compensation, their terms of employment, benefits, etc., treatment on the job, would be on its face unlawful. But we get into a lot more subtle issues with the policies and rules that I'm guessing all of you have in your handbooks and on the books right now. So let's take a look at this one as an example. Non-disparagement provisions. Okay, a non-disparagement provision is lawful to the extent it precludes statements about the employer that are made with knowledge of their falsity or with reckless disregard for their truth or falsity. Okay, that makes it lawful because we're saying it has to be knowingly false. It has to be you have to recklessly disregard the truth of the statement. But as you can see, it's not your typical garden variety non-disparagement that we usually see, and that I'm guessing some of you have in place, which is that you can't disparage the company, you can't make statements that could reflect negatively on the reputation of the company. Those, under Stericycle, would be unlawful. Let me give you another couple of examples. So this is one from the case. This is a conduct rule that was determined to be unlawful. Conduct that maliciously harms or intends to harm the business reputation of Stericycle will not be tolerated. You are expected to conduct yourself and behave in a manner conducive to efficient operations. Okay, so far sounds like a good policy, right? Like totally reasonable from the point of view of the employer. Failure to conduct yourself in an appropriate manner can lead to corrective action up to and including termination. Guess what? Unlawful. The idea is that an employee whose livelihood is dependent on the employer could read this and interpret it as preventing them from sharing information about the company, sharing information about terms and conditions of employment, and therefore chill their rights, their exercise of rights under the NLRA Section 7. And I'll give you one more and then we'll move on. Stericycle will not retain a team member who directly or indirectly engages in an activity that constitutes a conflict of interest or adversely reflects upon the integrity of the company or its management. Sounds perfectly reasonable, doesn't it? I mean, why would we allow our employees to do that? But again, unlawful, because an employee could interpret this as precluding them from exercising their rights to concerted activity. So here's what we need to do. Review your handbook policies, all policies, your employment agreements, and your severance agreements. Evaluate each rule or restriction and carefully consider its purpose. Narrow or eliminate the rule if the restriction consistent with the new standards. So if the restrictions could be interpreted as chilling Section 7 activity. And add carve-outs, something Larry mentioned earlier, carve-outs for protected activity under Section 7, so that you say something like, this policy is not intended to prevent you from participating in concerted activity consistent with your rights under Section 7.
This morning I am going to go over compliance with I-9 and some E-Verify requirements. This is where the employment law and immigration law intersect. And I'd like to go over the components of the I-9 form, common mistakes I see, common practices, and then some policies that are good to implement regarding I-9. So what is the I-9 form? The I-9 form is a form U.S. employers are required to complete for all individuals who they employ in the United States. It's required for all employees. It's required for paid interns. The instances when it's not required are limited to independent contractors, but obviously more often than not, it's required. So some basic components of it, things to be aware of. Non-compliance with I-9 can result in civil penalties, usually in the form of fines that escalate when there's a pattern of non-compliance, a pattern of employing unauthorized non-citizens in the United States. And then there are criminal penalties when it's an egregious pattern of employing unauthorized non-citizens in the United States. It's regulated by federal law. What I wanted to go over today is how to correct an I-9 that's was not completed correctly, retention of I-9s, and the timing of I-9s, because these are, I would say, the three major issues where employers fall into potentially non-compliance. So when does it need to be completed by? The employee needs to complete Section 1 of the I-9 form on the first day of his or her employment. The employer needs to complete Section 2 of the I-9 form within the first 3 business days after the date of hire. I wanted to show the actual form, and this form, I say it's deceptively simple. The instructions to it are actually clear, and they're usually on the form or in the M274 handbook, which I'll get to a little bit later, but it's a very valuable resource in terms of how to complete an I-9 and how to comply with these laws. But it states right on the form, employees must complete Section 1 no later than the first day of employment, but not before accepting the job offer. So employers cannot have candidates complete this form to evaluate if they're authorized to work in the United States and then decide we're not going to make an offer of employment because they're not authorized to work in the United States. So it's not before the job offer, but it needs to be completed no later than the first date of employment. And then let's look at Section 2. Again, right on the form, it says within 3 business days from the first day of employment, the employer needs to complete this section. So retention, how long does an employer need to retain the I-9 form? The law states that the employer needs to retain the I-9 form for every individual throughout the duration of their employment, but no less than 3 years from the date of hire. And then 1 year after the employment terminates, but again, no less than 3 years from the first date of hire. So that means that if an employee is hired, only works for the company for a year, the employer needs to retain the I-9 for 3 years from the date of hire, even though the employee only worked for the employer for 1 year, and the 1 year after the termination is really only 2 years total. The employer still needs to keep the I-9 for 3 years. Corrections, correcting an I-9, this is a question I get frequently. Employers will ask, well, we'll just have the employee complete a new I-9. We'll just rip the first one up and we'll have the employee complete a new one. That's not allowed. You cannot destroy the original I-9. Correcting it is a very specific procedure. The incorrect information needs to be crossed out, and the employee needs to initial that the correction was made. The corrected form needs to be retained, and there needs to be a written explanation attached to the form that explains the error and the steps made to correct it. When these I-9 forms are being completed electronically, which is increasingly we're seeing that they are being completed electronically, there's an audit trail that the electronic forms have that show the trail of corrections. So the incorrect information, the steps made to correct it, and then when the correction was completed. But that's a very common mistake that I see a lot. So then the third step in completing the I-9 is the physical examination of an acceptable document that verifies the U.S. employment authorization. Again, a common mistake is actively or even passively directing what document the employee provides. So there's the list A of acceptable documents, which is a document that both shows the identity of the employee and the U.S. employment authorization, or employees can provide a combination of a document from list B and list C, which again shows identity and the U.S. employment authorization. So if an employer even says something like, bring your passport to work on the first day so we can complete the I-9, can't make that statement, because then you're directing the employee that they have to bring a passport in order to complete the I-9. So the employer can make no statements with regard to what the employee uses to meet this requirement and what document he or she brings. Another mistake that I see is that the physical examination of the original document does not occur. So the employee may bring a photocopy of his or her passport, or a photocopy of his or her driver's license or social security card. That does not meet the requirement. The actual original document needs to be physically inspected, which means that the employee is handing his or her actual passport to the employer or an authorized representative of the employer, and the employer is examining it for its genuineness. Where this issue is coming up more and more is considerations for remote employees. So the last summer, the government went back to the requirement that the document be examined in person. There was an exception during the during COVID-19 where virtual inspection could occur. That is no longer the case, with the exception of if an employer is participating in E-Verify and is in good standing with E-Verify, then the employer can look at the document over a live video interaction. What that means is they're on a Teams or a Zoom, the employee is holding up his or her passport, the employer is looking at it for its genuineness. But again, that's only an exception for employers who are participating in E-Verify and in good standing with E-Verify. Otherwise, this physical inspection needs to occur in person, and remember, it needs to occur within 3 business days from the first date of hire. Re-verification when a document expires. So if a US passport expires, if a US permanent resident card expires, driver's license expires, you cannot ask for the new copy, the renewed document. Re-verification when a document expires, those documents are really limited to like a temporary employment authorization card. The rules regarding re-verification are very specific to the type of document. So that's why I provided these excellent resources that are available on uscis.gov. I-9 Central is very helpful. And then the M274 handbook for employers is very good, and it's very clear on how employers can comply with I-9.
And you said you can't guide people what to bring. The government just say, look, if you go to column A, you can just have that. But if you go to column B and C, you need both. We're not telling them what to do, but we're saying that you need both.
That clarification is fine, yeah. Like to explain that it's one document from list A or a combination of list B or C. Just not referencing specific documents from either list. Last December, the government released this is an other good resource on how to avoid non-compliance when you're using an I-9 software program, which again is an increasing trend. Software programs that pre-populate information, auto-populate information, don't allow for certain fields to be left blank. They are not compliant with I-9. So employers have to be very careful in which software programs they use, and as the form clearly states, the employer is liable. Like Michelle was saying earlier, you can't sort of state that, well, the program was wrong. And then a quick introduction on E-Verify. E-Verify is optional in most cases. That's a question I get a lot is, well, do we have to do E-Verify? No, but there are advantages. E-Verify is a program where you input an employee's information and the government does a cross-check to help verify, like cross-check other databases to help verify that the employee is authorized to work in the United States. My quick bullet points on E-Verify is you can't dabble in it, you can't use it selectively. You have to, once you sign the memorandum of understanding and sign up for E-Verify, you have to use it for every single new hire. You can't stop using it for a certain amount of time and then restart. You have to commit to using E-Verify, and you have to use it consistently and for everyone. The benefits of using E-Verify, one is that it is a reliable database to show whether the individual is authorized to work in the United States. It's pretty good at doing that check. And another benefit is if you have a remote workforce and you're maintaining good standing with E-Verify, you can do that virtual inspection of the acceptable document over the live video chat to ensure that you're complying with I-9. And then one other important note is that E-Verify doesn't replace I-9. It's not as though you can use E-Verify in lieu of I-9. E-Verify is a separate, most times optional program that works sort of in conjunction with I-9 to help verify that you're employing individuals who are authorized to work in the United States. So I think that is all I have on I-9 questions. Yes?
I was told that we could have a representative of our company, or if say we only had one employee we're hiring here.
Yep.
I was also told that we could use someone else, maybe like a building management or a neighbor, I would be told, to verify the document.
It has to be an authorized representative of the company.
Okay.
So I mean, we can speak about this separately. I would not advise using a neighbor or a building manager. But it does not have to be like the specific company representative who does all of the other physical document checks. That person does not need to go fly to San Francisco. You can designate someone else from the company to do that physical examination. Yeah.
If the employee does not fully fill out the form or incorrectly fills it out, could that create liability for the employee?
Yes. Yes. It's the employer's responsibility to make sure that section 1 of the form, which is completed by the employee, is completed properly, but the employer can't make those corrections. So the employer would have to go say to the employee, this part was not completed correctly, and then the employee needs to make the corrections.
So we have some electronic employee files that we plus we have.
That's okay. It can be a combination of like a physical folder with I-9s and electronic retention. It can be a combination of both.
Good morning, everyone. I'll be discussing another tried and true topic. This is reasonable accommodations. Probably a set of buzzwords you all have heard before. I don't have any, up and coming or recent developments, but because this issue is recurrent, it's evergreen, we felt it would be good to give an overview, a primer on it today. I'll be covering generally 3 laws as they apply to you as Massachusetts employers. You have the ADA, Chapter 151B, which is Massachusetts law, and then the Pregnant Workers Fairness Act, which has a federal and Massachusetts counterpart. There may be other laws, as has been said earlier. If you operate in other states, other laws to pay attention to, that state's laws. But because most of you operate in Massachusetts primarily, we'll be focusing there. So when it comes to reasonable accommodations, there's really 3 steps to consider. The first is the individual legally disabled, as that term is defined under the ADA in Chapter 151B. Step 2 is, has the employee requested an accommodation, or do they appear to need an accommodation? Are they regarded as needing an accommodation? We'll get into that. And then step 3 is the requested accommodation, if they brought up a specific one, or if you're working through different accommodations to deal with, is that accommodation reasonable? And all 3 of these steps are things to consider as you're working through the process, and each one can be outcome determinative. And what I mean by that is, if step 1, is the individual legally disabled? If the answer is no, then steps 2 and 3 don't apply. Step 2, has the employee requested an accommodation, or do they need an accommodation for some other means? If the answer is no, then you don't have to get into the question of whether that accommodation is reasonable, because there won't be one. So the first step deals with disability. An employee under the ADA and 151B, though it uses the term handicap. An employee is disabled where they have a physical or mental impairment that substantially limits a major life activity. And it's not just whether they have an impairment, currently at that point in time, but whether they have a record of having an impairment or are regarded, so perceived, considered by you as having an impairment. All 3 of those categories bring with them the legal protections of the laws that I'll be talking about today. As far as what a major life activity is, and this is a non-limiting list, but it includes things like walking, seeing, hearing, learning, speaking, performing manual tasks, the things you do as a human being on a day-to-day basis. And depending on the particular job that someone is performing, these impairments can run the gamut. So you have mobility issues. If you have stairs in your building, going up and down stairs, sitting down for long periods of time. If someone drives for long hours, night blindness can sometimes affect them. Intellectual disabilities, mood disorders, or even just medical conditions like diabetes, MS, even cancer, all of those things can fall within an impairment depending on how it impacts the particular employee. And it is safe to assume that someone who has a medical condition that substantially impairs their life, their activities, is likely to be disabled. And so if that happens, you should begin to consider whether and how reasonable accommodations come into the picture. So what is a reasonable accommodation? It's an adjustment or modification that enables a disabled person to perform the essential functions of their job. And just like there's a wide range of impairments, there are a wide range of accommodations that can be implemented. Physically modifying a workstation, so standing desks as opposed to just sitting in one place stationary all day long. Modifying a schedule, again I mentioned night blindness, so adjusting the hours to account for that condition. Modifying when or how a particular task is performed. Light duty is another option which you may have heard of, so shifting work within the person's job that's less physically or mentally demanding than their usual activities. And then time off or leave is sometimes part of the equation as well. Once you become aware that an employee is or has become disabled, you should consider whether a reasonable accommodation is required. And this can happen when an employee comes to you and volunteers that information, or again, if you begin to regard them as disabled, or if you learn they have a record of being disabled. But I do want to focus on the first of these because it's a common question, right? An employee that you have comes to you, brings a disability to your attention, and they request a specific reasonable accommodation for their condition. Do you have to give that reasonable accommodation? The answer, it depends. Like everything in the legal field. It depends on whether the requested accommodation is reasonable. What is a reasonable accommodation? It's one that does not create an undue hardship for you as the employer. And these undue hardships can be a variety of different things. It can be financial, so if the accommodation costs too much money. If it's operational, it affects the efficiency of the workplace, or creating a threat to the health or safety of that employee or others. One way to work through whether or not an undue hardship is implicated is to have an interactive dialogue with the employee, and in fact, it's required to have this open and an ongoing conversation with the employee, sometimes the employee's medical providers as well, to figure out what is going to work best for them and for you as an employer. And the best recommendation is to be flexible and creative with how to problem solve for that employee. I mentioned leave or time off. This is often an appropriate reasonable accommodation depending on the disability that you're dealing with. And if you decide to give it as a reasonable accommodation, it can overlap with or extend other entitlements to leave that the employee may have, whether that be under your company's policies or the state and federal laws that apply. So we're talking sick time, FMLA, PFMLA, other medical leaves of absence. When deciding whether or not time off works as a reasonable accommodation, you should check your handbook, company policies, make sure you know what is provided for, as well as whether any laws come into play. And of course, if you have any questions, we're always around to answer them. But as far as what's reasonable for time off, the only real rule of thumb is that an indefinite period of time off is not reasonable. Now, you can have a certain period of time where they come back and they maybe bring a doctor's note that has a re-examination. They say, I need an additional period of time. That can be reasonable. But in determining what type of length you're okay to offer, you can absorb, you should consider whether that employee's role can be temporarily replaced or whether their responsibilities can be shifted to or shared by others. These are factors that you can consider in determining not only whether time off works for you as a reasonable accommodation and for the employee, but also how long that time off will be. But time off as a reasonable accommodation in and of itself doesn't need to be paid. However, your policies and other state and federal laws, as I've mentioned, may require payment or allow payment. So again, PFMLA, short-term disability, long-term disability, depending on your policies, workers' comp, these are different pieces to think about. And while they won't be accruing time off during the leave as a benefit because they're not actively employed in doing, they're not actively doing work, they're still employees of the company, right? This is leave with job restoration when they return. So they're still entitled to health coverage as long as it's handled just the same as if they were in the office working, and maybe other benefits depending on your policies, insurance, retirement, pension, all of those can come into play. Just very briefly about individuals who are applying to jobs and not currently employed. the requirement to provide a reasonable accommodation can still come up in this situation. So if you have a job applicant that has a disability, as I've talked about today, and falls within that definition, and requires a reasonable accommodation, you need to have that dialogue with them. So different examples of this can include things like if you have a job applicant who is blind, providing an application to them in Braille. If you have a job applicant who again has mobility issues and your office is located on the second floor, well, consider whether or not you can do a virtual interview with the person, or maybe meet on the ground level or at a nearby location that is on the ground level. And again, just to briefly touch on this, because it's not the main topic at issue, but the Pregnant Workers Fairness Act carries with it reasonable accommodation requirements as well that may come into play. As I mentioned, there is both now a federal and Massachusetts counterpart, and you should be aware of both. Those who fall under these laws may require reasonable accommodations, just as with disabled employees, but this time it's for a pregnancy or childbirth-related medical condition. Now, what are those? Morning sickness, gestational diabetes, hypertension, or carpal tunnel that may be caused by the pregnancy, lactation or expressing breast milk, which may continue after the birth for a period of time, and also up to issues of recovering from a miscarriage or even postpartum depression. All of these can implicate the Pregnant Workers Fairness Act. You've got the same undue hardship standard that's in play and the same interactive dialogue that you would go through for a disabled employee. But there's a key difference as far as state and federal law is concerned here. When you're dealing with the Massachusetts law, which applies to any employer that has 6 or more employees in Massachusetts, it's the same sort of accommodation is only required, or reasonable accommodation is only required if the employee can still perform the essential job functions of their role. However, when it comes to the federal law, which applies to any employer that has 15 or more employees, they don't have to still be performing their essential job functions in order for the protections to kick in. Under the federal law, if the employee has a temporary inability to perform, or no accommodation could enable them to perform for a period of time, as long as they can perform in the near future, they can be temporarily excused from performance under those circumstances. So it's just a key distinction to maintain awareness of. Now, another one of the big questions surrounding this topic is, okay, I've given a reasonable accommodation. Now, how long do I have to keep it in place? And again, I hate to use the word, but it does depend. It depends on you as an employer and what you can absorb, what you can handle. It depends on the employee and their specific requirements, the disability condition that they're dealing with. But you should plan to accommodate until either there is no longer a condition that needs to be accommodated, or until the accommodation begins to create that undue hardship. And even if you begin to approach that undue hardship or think you may be entering that territory, you should try and keep up the dialogue with the employee, continue to evaluate the situation, and see how you can work with them. And remember, it's okay to involve the employee's medical provider or to ask the employee to provide some documentation, especially if you harbor a doubt that the disability is continuing for whatever reason, or you need additional information to help the employee navigate their duties and responsibilities. But it can get complicated as these continue to carry on. So again, if you have any questions, we're only a phone call away.
At what point can I ask for that documentation, or the proof, if you will?
Yeah, I would say that if this wouldn't necessarily apply to your situation, but if the disability is pretty evident, right, then asking for or requiring you could be, opening yourself up to some issues there. But if you have any doubt, or even if you just it's under the I need more information in order to provide you what you may need, or to understand what you're dealing with and how it affects the workplace, it's certainly permissible to ask for or require a doctor's note in that situation. And if the employee refuses to provide it, then that may give you the ability to not grant the request if you so choose, or to offer a different request that doesn't match what they've specifically asked for.
How do these accommodations work for paternity leave?
Paternity leave?
Yeah.
So it's kind of so that's one of the ways in which maybe you don't need to give a reasonable accommodation necessarily because they're already covered under the PFMLA that may apply to them, or even the FMLA for an extended period of time with no pay but job restoration. So in that situation, the individual is not dealing with a disability. They're just going to take care of a child. So the PFMLA would kick in for them. But if you've got an employee that falls within the Pregnant Workers Fairness Act, if they need an extended period of time off as a result of pregnancy-related conditions or complications, then you could consider whether or not that time off would be reasonable accommodation or whether there's some other way that you could make it work.
Question about light duty. If you know when people are light duty and they kind of say, well, I need to always be at light duty, is there a way out of that?
I think at that point you could involve their medical providers. There's also independent medical examinations, or IMEs is another way that you could do it. So if you want to get someone who's neutral to examine and determine what the disability related needs are, I certainly think the longer, maybe not right away, but the longer it goes on and the more it seems like the employee is not in good faith participating in this interactive dialogue with you, the closer to requiring that or considering that as an option.
Okay, now we're going to talk about worker classification issues. And this would be pertinent under the Massachusetts Wage Act with respect to employees versus independent contractors, and under both the Massachusetts Wage Act and the FLSA with respect to exempt versus non-exempt classifications. So we're going to start with the difference between an employee and an independent contractor. Okay, an employee is typically a payrolled worker. They get benefits. You take from their payroll check deductions and withholdings, and you meet the requirements of state and federal tax laws and various agency requirements such as unemployment, Paid Family and Medical Leave Act, FICA, which is Social Security, and also, of course, your state and federal income tax withholdings. This is covered by wage and hour laws because this is an employment relationship. Independent contractors, on the other hand, get a 1099. They do not get a W-2. They typically do not get benefits. You would not be withholding any tax money or contributions for unemployment or PFML from their pay, and they're not covered by wage and hour laws. This is an issue that's been coming up for years and years, and still many of my clients misclassify their employees, some of their employees, as independent contractors. And the reason this happens is because it's very, very difficult to properly, lawfully classify a worker as an independent contractor. We have the three-prong test in Massachusetts, or people call it the ABC test. And the individual has to meet all three of these requirements in order to be properly classified as an independent contractor in Massachusetts. So the first is to be free from control and direction and performance. They make their own hours. They choose how to do things, when to do things, free from direction and control by a supervisor. The second prong is that they perform services outside the usual course of the employer's business. So this would be a situation where somebody is doing something totally outside what you do as a company. The very clear example I often give is someone comes into Davis Malm to build shelves in a closet for us. Okay, that is not within the ordinary course of what we do. And then the third prong is that the individual is customarily engaged in an independent, established trade, occupation, profession, or business of the same nature as the services they perform. In other words, they have their own side business. They have their own business through which they provide these services. So frequently, I find that folks who are classified by my clients as independent contractors meet one or two of these, but not all three. And it's very nerve-wracking, I find, for employers to make the change and switch people over from independent contractor status to employee status. But it has to be done, and often, we're able to work through this. We typically do it at an appropriate time, like the beginning of the fiscal year, the beginning of the calendar year. We try to do it in connection with performance evaluation, a raise, a bonus. And at that point, when people transition onto payroll, who have been treated previously as independent contractors, we talk to them about the benefits of being an employee. And clearly the purpose of this law is to protect people. It's to protect their right to get benefits, to have payments made to PFML, paid family medical leave, to have payments made into unemployment for you. And so there are ways of making that transition. If you need to make that transition, or your clients need to make that transition, it's something that we can work through with you. It is critically important. Sometimes people will say to me, well, they're only part-time, or well, they only work occasionally. Doesn't matter. If they don't pass this 3-prong test, they are employees. So once we properly classify someone as an employee, we then look at whether they're exempt or non-exempt. And we look to the FLSA, which is also consistent with the Massachusetts Wage Act, to determine whether they are exempt or non-exempt. If they're non-exempt, then it means the law applies to them with respect to minimum wage, which is $15 in Massachusetts, $15 an hour, and overtime pay. So overtime pay is all time that's worked in excess of 40 hours in a regular work week. It is paid at 1.5 times the normal hourly rate, and again, in Massachusetts, our minimum wage is $15 an hour. All right, how do we determine whether someone is exempt or non-exempt? So again, the assumption is that people are non-exempt, that this applies, that the law applies, they have to be paid minimum wage, they have to be paid overtime. But there are many exempt categories, and they include, or they consist of the executive exemption, administrative, professional, outside sales, certain computer jobs, and highly compensated employees. We look at the duties test, which is these various classifications, and we also look at whether they meet the salary basis rule, the minimum annual salary. Both of those have to be met. The minimum annual salary amounts are increasing over time. The annual wage for exempt workers that's required in 2024 is $43,888. In 2025, it'll be $58,656. Now, turning to the duties tests that we look at, okay, what does it mean to be an executive for purposes of the exemption? And the focus is that they're managing an enterprise or a recognized department or subdivision of the company. They're also customarily directing the work of at least 2 people, so they have direct reports, and they have the authority to hire and fire. So there's independent discretion and judgment with respect to recommendations for hiring, firing, advancement, promotions, and other change in status of employees. That's your executive exemption. Your administrative exemption. These employees' primary duty must be to perform office work or other non-manual work related to management or general business operations of the company. And their primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So again, discretion, independent judgment, important pieces that we look for. And I always tell my clients when we're drafting the job descriptions, be careful what verbs you use. You want to use verbs that indicate the level of independent judgment and decision-making responsibility, as well as the particular duties that might be pertinent to the exemption that applies to that individual, to make sure that we're clear in the job description that this is an exempt position. And then we have the professional exemption. This is where the primary duty or performance of work requires advanced knowledge, and this would be primarily intellectual work or work that requires exercise of discretion and judgment, advanced learning. Oftentimes these are jobs that require degrees, science or learning, and advanced knowledge must be customarily acquired by a prolonged course of specialized intellectual instruction. These are your professionals. Then we have certain computer jobs that are automatically exempt. I won't go through these. You can take a look at the slides after. And then we have a special category for highly compensated individuals. And this category is for folks in 2024 who earn $132,964 a year, in 2025, 151, 164. But just getting paid a high wage that's over this threshold is not enough. They also have to regularly perform at least one of the duties of an exempt executive, administrative, or professional employee. So it's a combination of those white-collar exemptions plus the amount that they're paid. So just keep in mind, this came up earlier, under our Wage Act, we have treble damages, triple the amount that is unpaid or owed, unpaid and owed, plus we're liable for attorney's fees and costs. With respect to the Internal Revenue Service, the Department of Revenue, the Paid Family and Medical Leave Department, the DUA, the Department of Unemployment Assistance, you are subject to investigations and penalties. And I've lived through these kinds of investigations with my clients, and believe me, it's not something that you want to subject yourself to. Also, very importantly, under the state law, individuals are responsible, are liable under the Wage Act. Triple damages, attorney's fees and costs, and this can be presidents, treasurers, officers, or agents who have responsibility for management of the company. And another Wage Act issue that I want to bring to your attention, this is relatively new law, and it's worth pointing out. This case, Reuter versus Methuen, reiterated and enforced very aggressively that final wages, including accrued and unused vacation pay, must be paid on the last day of employment, not the day after, the last day of employment. And believe it or not, automatic liability for the triple damages and the attorney fees and costs result from any late payment. So sort of the common wisdom in terms of dealing with this sometimes very, very, really impossible requirement is that if somebody resigns immediately, or if you're ready to terminate them immediately because of some egregious conduct, you put them on a paid leave of absence. They're out of the workplace, they don't have access to your premises, they don't have access to your computer system, but it gives you the time that you need to tee up that final paycheck, including their accrued and unused vacation time. And one little side note, when we say accrued and unused vacation time, if you have PTO that includes vacation time, then it's that PTO, that accrued and unused PTO, that has to be paid out on the last day of employment as part of final wages. Any questions?
Voluntary, like someone resigns but gives 2 weeks notice, and we pay twice a month. Say, can we pay them that on their regular schedule? That has to be the final.
Not if the employee voluntarily resigns.
That's what
Yeah.
I'm saying.
If the company terminates you,
Right.
you have to pay them on the day of termination. If the employee voluntarily resigns, you have to pay the following payroll.
Yeah, perfect, great.
That's right? Okay.
So say we are terminating someone and then we do a next day direct deposit, so we technically pay them on their termination date, but then they don't, the bank doesn't release their funds until the very next morning.
Yeah, I would recommend that you make that next day their last day of employment.
Yeah, and I would
Yeah.
say that under that case, the court made a statement to the effect that the employer takes the risk of whether it's done correctly and on time. So it's up to you to make sure it happens on time. And something like that, you could say, oh wait, it wasn't me, it was the bank. It's your problem, not the employee's.
The employer's responsible. I'd like to introduce Dave Rogers. In addition to working here as an attorney at Davis Malm, he is a state rep. He represents the 24th Middlesex District, which includes Arlington, Belmont, and part of Cambridge, North Cambridge, right? Yeah. Thanks, Dave.
Yeah. I do mostly business law, corporate law, advising companies on a variety of things, and some employment law related to the business transactions, and also serve in the Massachusetts State House. And I've been there 12 years. Fortunately, I have no opponent this cycle, so I guess I'll be there another 2 years, unless blank beats me, and that would be bad.
Dave, we have a rule here, no political discussions in the workplace.
Oh yeah, there you go, there you go. So I'm going to talk to you with updates from the State House. This is legislating that we've been doing recently. And the biggest new law that we passed is the salary transparency law. And that has not taken effect yet and won't take effect till next year. But it's good to just be aware of what's coming in the future. And basically any employee, public or private, with 25 or more employees in Massachusetts will have to disclose the pay range of new positions. And it's not just when you post a new job posting, it's also for those in your company who apply for a promotion. It's also just anyone who holds the position, say there's 10 sales reps or whatever the job is, and they say, hey, what's the salary range for my job? You know, and so they could be currently working with you and ask for that information. So it's pretty broad in that respect. And then that one sentence at the bottom is really important. It's illegal to discharge or discriminate against an employee because they exercise their rights under that section. So if they say there are 10 sales reps and one of them asks for the information, you can't say, well, this guy's troublesome and difficult. And the reason I mention that is some of the employment lawyers will tell you in job discrimination cases, the employee can't win on the merits of their discrimination claim, but they can win for retaliation or for taking any action because they've exercised their rights. So the other key piece of this is annually on February 1st, employers with 100 or more, so the salary is 25 or more. This is for employers that have 100 or more. You have to disclose your EEO-1 report to the state now. It's already disclosed to the federal government, but now you'll also have to disclose it to state government. And it's anonymized, but it's to give the state a sense of what's happening in the marketplace. The effective date for the salary is not until October of next year. I saw a major law firm in town. I happened to look at they sent out an alert and they said it's July 31st. And that's incorrect. It's not till the end of October of next year. And that was a complicated negotiation between the governor and the legislature. There's a soft, if you will, a soft opening to this new law. That is, for the first 2 years, as long as you correct or remedy any violation, there'll be no penalties, no fines, no ramifications. So I thought that was a sensible, it's a pretty sweeping new law, give employers a full 2 years to kind of implement it, and if they make a mistake or omit certain information, there's a grace period for a full 2 years. Yeah, I think the idea is to get the data and understand how the pay structures are working in various sectors and various SIC classification codes, to get a sense of are there persistent pay gaps. And so, but it's anonymized, as I say. No employer will ever have their information public, and I believe specifically it's the Secretary of State's office, or it could be the Executive Office of Labor and Workforce Development, or both. The next one is the so-called topping off law. We know we have PFML here, Paid Family and Medical Leave. That's a relatively newer law, and it's gotten a lot of publicity around the country. Many other states have it. I think when Tim Walz was selected to be the Democratic nominee, there was publicity about how Minnesota has this law. But what this will allow to do is the pay replacement currently under PFML is not your full wage replacement. And this allows employers, if they want to allow workers to use accrued benefits like earned sick time, vacation, to top off their PFML. It cannot exceed their IAWW, their individual average weekly wage. And the employer will be responsible for monitoring that compliance with that prong of the law. And the theory behind it is to create a competitive advantage for particularly our tech sector, but many sectors competing with other employers around the country. It's a way to offer a benefit to your employees. And so there was a big debate about when to make it effective. November of last year. I think some of you already are calling in with questions about how it works, and obviously pick up the phone or shoot us an email and get in touch and if you have questions about how to implement it. The next thing that's new is part of a big comprehensive tax package we did recently. I don't know if any of you use registered apprentices, but we expanded that program to more types of jobs, particularly in the healthcare sector, high in demand professions and jobs where the state frankly is having worker shortages. So the theory is to offer the incentive to boost employment in those areas, and employers who use this are eligible up to $100,000 of credit each calendar year. So if you do happen to use that program, let us know. We can give you specific details as to which jobs are covered. And this is a lot of complicated discussion of who qualifies, but the expansion includes certain life sciences, lab workers, healthcare technologists, and a variety of others. But if you use the program, get in touch and we can let you know if the particular employee is covered. The final thing I'll talk about, as you may have heard, there's an election this November. When you go to vote on all the other issues and all the other candidates, there are ballot questions. The one ballot question I want to talk to you about is the Uber, Lyft, transportation network driver ballot question and whether they can unionize or not. Many of you may have seen the Attorney General. Well, the Attorney General is now the governor. Maura Healey sued these companies, claiming they had misclassified these drivers. You just heard from Tamsin about misclassification. If nothing else, the takeaway is how dramatic the ramifications can be for misclassifying your employees. And you recall the example Tamsin gave that, is this outside the normal scope of what your company does? Well, saying that your transportation driver is outside the scope of what Uber and Lyft does presented a problem for these companies. But there was a settlement. And the settlement guaranteed these workers certain rights. I think $32.50 an hour is a base minimum wage, and a whole variety of other rights that the current Attorney General, Andrea Campbell, entered into the settlement. Now the question will be for all of us to decide as voters in Massachusetts, should they be able to unionize? Because they are still independent contractors, so typically they wouldn't have this right. And the question is, should they? But again, the big takeaway, I think, is to reinforce what Tamsin was saying about misclassification and how dramatic the impact can be when that happens.
And have a great day. Thank you.